So we will examine some important sections under the Negotiable Instruments Act 1881. The Negotiable Instruments Act plays a very important role in banking operations. I think most of you will be knowing that the holidays in banking sector has been issued under the Negotiable Instruments Act. That means that even if the normal holiday will not be applicable to banks unless it is issued a holiday under the negotiable instruments. That means that negotiable instruments cannot be exercised during the days of on so and so date. Then that days will be called as a public holiday. So Negotiable Instruments Act plays a very important role in the operations of banking activities in India. Is okay, Varsha? Second screen is visible,
yes,
no?
Yes.
Yeah. So we will first of all discuss about what are negotiable instruments and what is the meaning of negotiable instruments, why it's called negotiable instruments. So Section 13 of the NI Act says that the negotiable instruments means and includes promissory note, bill of exchange, and checks payable to order or to bearer. So there are three important instruments, negotiable instruments as per the NI Act. One is a promissory note, other one is bill of exchange, and third one is check payable to order or to bearer. Check payable to order means, suppose if you are paying to a certain person, if I can't pay check, it's called checks payable to order. Or if it's the bearer, means the person who's coming with a check, who's coming to a branch with a check is called the bearer. So the check payable either to the bearer or to the order is also called a negotiable instrument. And what is the negotiability? Transfer of the instrument to any person so as to constitute him the holder. Negotiability means you are transferring the instrument so as to entitle that person the owner of that instrument so that he can go to the bank and withdraw the money from the bank. Yeah, Section 14 defines negotiation. Says that when a bill is transferred for consideration to any person so as to entitle him to claim the amount represented by bill, then such transfer is called a negotiation. So some person is giving a check, bill of exchange, or promissory to some other person as a consideration. Suppose after receiving a service of so and so from A, you are giving a check to A. So there is a valuable consideration is that you are transferring that check so as to entitle that person to go to the bank and receive the money. So when a bill is transferred for consideration to any person so as to entitle him to claim the amount represented by the bill, then such transfer is called a negotiation. So who is a holder? Section 8 of NI Act defines a holder as a person who is entitled in his own name to the possession thereof. That means that if I am entitled to receive the check on my behalf, in my name, is called the holder. Section 9 defines a holder in due course, a person who must have the instrument in possession. Even though you are not in possession of the instrument, but you are supposed to be the person in holder, means that is called the holder in due course. Suppose A is given a check to B, that beneficiary is C. So B may be holding the check, but ultimately the check has to be given to C. So C is the holder in due course, even though he is not in actual possession, physical possession, but is a person who is entitled to receive the payment. That is called the holder in due course. Now, what is a promissory note? Promissory note is an instrument in writing containing an unconditional undertaking or promise signed by the maker to pay a certain sum of money or to the order of a certain person or to the bearer of the instrument. So basically, promissory note is an instrument in writing. So you have to, a promissory note is an instrument in writing. It's contain an unconditional undertaking or promise. So somebody is giving an undertaking, somebody is giving a promise signed by the person, signed by the maker. The person who's giving you the promissory note has to sign it. And what is the undertaking? To pay a certain sum of money or to the order of a certain person or to the bearer of the instrument. That means that he is undertaking that I will pay so much of amount of money to you, or I will pay so much of money to the person who is coming up with this instrument. So Promissory note is an instrument in writing containing an unconditional undertaking. Unconditional means there should not be any condition. I'm promising that you will receive this money if you on so and so date if you bring this note. That is what the unconditional undertaking, and it should be signed by the maker to pay a certain sum of money. So undertaking is to pay a certain sum of money, or to either to the order, the person who's mentioned in the bill, or to the bearer, the person who's carrying that instrument. So he date promissory note. I think nowadays promissory note, I'm not sure how much is available in the market now because of this online transactions. I think this the demand for all these checks and promissory notes has reduced a lot. So this is an old check, old promissory note. It says that on demand we promise to pay at the Imperial Bank of India, Rangoon, for valid receipt the sum of rupees 22,000 only with interest thereon from this date at the rate of 6.5% per annum. So this is an undertaking that he will pay 20,000 with interest at the rate of 6.5% from on the day on which this instrument is produced. This is on 16 December 1926. So this is a promise to pay a certain sum of money on a particular date or the day on which the instrument is produced for produced, and that day the money will be paid. The section 5 defines a bill of exchange. A bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money. In bill of exchange, it's a direction upon the bank to make the payment. Promissory note is actually undertaken by a person itself. That is, I undertake that I will pay you so and so money on so and so date. In the case of bill of exchange, the check is a bill of exchange. So a bill of exchange is an instrument in writing. It contains also, just like an unconditional undertaking, it is contain unconditional order signed by the maker directing a certain person. So in case of check, a drawer is directing the bank to make the payment. So directing a certain person to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So as particular person, the person whose name is mentioned, so he is directing the bank to make the payment to so and so person who comes with the check, or making 86 days after the date we promise to pay so and so person the order of sum of rupees so and so 2,000 rupees for value received in cash this day. So this is it is not the bank. It is actually it's called a hundi. Hundi means it's a promissory note by which a person is undertaking that he will make the payment to so and so person on so and so day. Now, as I told, check is a bill of exchange. So section 6 of NAI defines what is a check. A check is a bill of exchange. It says that check is a bill of exchange drawn on a specified bank and not expressed to be payable otherwise than on demand. Check is always payable on demand. On demand means whenever you record money, you can go and demand it. So whenever the check is presented uh, presented to the bank for collection, at that time the amount need to be paid. So check is a bill of exchange drawn on a specified bank and not expressed to be payable otherwise than on demand. When the check is presented only, you need to make the payment, otherwise you don't have to make the payment. That is, means that it has to be paid otherwise than on demand. If it's demanded, then payment has to be done. So this is a check given by Ishtaq Ahmad to Diju Ranjan. So he's saying that pay Diju Ranjan 1,000 rupees. So this is issued by State Bank of India. So drawer, that in this case, the drawer is the Ishaq Ahmad and the drawer is the State Bank of India and the pay is Diju Ranjan. So this is a, I think, self-made check. This is a draft. I'll just come to the check. The important the parties to a check. Let me see. After that, I will come to that picture. So there are three parties to a check. One is a drawer. The person who is an account holder is called the drawer. Suppose a person is having an account with the State Bank of India, is the drawer. Drawing bank with whom the account is maintained. Suppose he is having an account with State Bank of India, he is an account with the Canara Bank. So the bank which is holding the account is called the Troy Bank. And pay the person named in the check. So pay the person means the beneficiary whose name is mentioned in the check is called the pay. So these are the three parties to a check. So check also means a check in electronic form and truncated check transacted during the clearing process. Checks have an electronic payment system where the check is electronic image of the check is taken and it's sent for collection, and only electronically only all these transactions are happening now. So the truncated check, physical, in case of truncated check, physical moment is stopped and its place, its electronic image is used for collection and payment purpose. Electronic check means exact mirror image of the paper checks. So the branch will send the electronic image of the check to the clearing house. On that basis, the clearing will be done. On that basis, the payment will be done. There is no physical movement of checks now. Previously, all the checks used to be sent by physically only. Now, all this has been electronically done. So, Section 31 laid down the duty of banker to make payment of check on behalf of its constituent. It says that drawee of a check having sufficient funds of the drawer in his hands properly applicable to the payment of such checks must pay the check when duly required to do so, and in default of such payment must compensate the drawer for any loss or damage caused by such default. So Section 31 lays down a duty on the banker to make payment of check on behalf of his constituent. That means that if there is a sufficient money is available in the account of a customer, it is responsible of the bank to honor the check issued by him. If bank failed to honor the check, then the account holder is entitled to claim compensation against the bank. So the drawee of a check, that means the person who is signing the check, having sufficient balance, sufficient funds of the drawer in his hands. Suppose the bank is having, drawer is the drawee of the check. That means the bank is maintaining the account. Bank is having sufficient balance of account of a particular person. Then bank is under obligation to honor the check. Such check must pay applicable to the payment of such check must pay the check when duly required to do so and default of payment. So if there is a default on the part of the bank in making payment of a check, then bank is liable to pay compensation to the customer. Must compensate the customer for any loss or damage caused by such default. That is what Section 31 says. Then what are the protection to a banker when they are doing the transactions on the basis of the check? Section 10 says that payment in due course means payment in accordance with apparent tenor of the instrument in good faith and without negligence to any person in possession thereof under circumstances which does not afford a reasonable ground for believing that he is not entitled to receive payment of the amount therein mentioned. So payment, see, when a check is in order means check is bank is supposed to make the payment in due course. Payment in due course means payment in accordance with the apparent tenor of the instrument in good faith and without negligence to any person. That means when the check comes for collection, the bank should see that there is sufficient money in his account, and there is no forgery on the check. For check is genuine and in good faith and without negligence. Bank should act in good faith and without negligence. So when a check comes for collection, if the bank feels that the check is not tampered, there is sufficient balance in the account of the customer, then bank is bound to honor the check. So in case if the bank failed to do it, the bank is liable to pay compensation to the customer. So bank should have there should not be a circumstances which does not afford a reasonable ground for believing that he is not entitled to receive payment of the amount therein mentioned. Suppose if there is a doubt in the mind of the bank that there is a forgery, is there, this person is not entitled to receive the payment, then bank can return the check. But bank should have a sufficient reason for disordering this check, and the reasons for disordering should be mentioned to the customer. That's why when you are filing a case under 138, the bank should mention on what is the reason the check has been returned. Maybe some cases maybe insufficient of funds. Some cases the signature is not tallying. Some cases the checks may be stale. That means that now, as per the RBI instruction, the period of validity of check is 3 months. Previously it was 6 months. Now it's 3 months. If the check is presented after 3 months, it will not be honored. So the bank has to give reasons on what ground the check is got dishonored. Section 85 says that where a check payable to order purpose to be endorsed by on behalf of the payee, the drawee is discharged by payment in due course. So if the check is payable to order or purports to be endorsed or by on behalf of the payee, so suppose the check is payable to a particular person and he has endorsed the check, the drawee is discharged by payment in due course. Suppose endorsement is in order, the bank is entitled to get a protection. So a check is drawn in favor of so-and-so person, drawn in favor of an order, drawn in favor of such a particular person, and is endorsed in favor of another person. If the endorsement isn't right, the bank has got a right to make the payment to the endorsee. But when the check is originally expressed to be payable to bearer, the drawee is discharged by payment in due course to the bearer thereof, notwithstanding any endorsement, whether in full or in blank, appearing thereon, and notwithstanding that any such endorsement purports to restrict or escort further negotiation. There is a saying in banking circle that's once a bearer, always a bearer. Suppose a bearer check is there, then the bank is bound to make the payment to the bearer. If there is further endorsement is there, the bank is not liable to verify the endorsement, because a bearer check, once a bearer, it's always a bearer. That means a bearer check cannot be further endorsed. Bank is not bound to verify the endorsement. Bank can make payment to the bearer. Section 89 says that where a promissory note, bill of exchange, or a check has been materially altered but does not appear to have been so altered, or where a check is presented for payment which does not at the time of presentation appears to be crossed or to have had a crossing which has been obliterated, the payment thereof by a person or banker liable to pay the paying the sum according to the apparent terms thereof at the time of payment, otherwise in due course, such discharge such person or banker from all liability thereon, and such payment shall not be questioned by reason of the instrument having been altered or the check crossed. The question is that the bank, suppose if there's an alteration in the check, and if the bank make the payment, the bank is liable. Section 89 says that if as per the bank's examination, if it appears that there is no alteration, subsequently it may be subsequently maybe further examination, if you prove that there was an alteration, but apparently at first instance the bank feels that there is no forgery, there is no temperament, then bank will get protection under section 89. So the means at appearance, the check should be in order. Check should not be found to be tampered. In such event, the bank will get protection. When the customer's signature on the check is forced, there is no mandate to the bank to pay. The question is whether a forced signature, whether suppose later on is found that the signature is forced, whether the bank has got protection. It says that if the signature is forced, then bank does not have any mandate to act on the basis of the instrument. So in case of forced signature, bank is not entitled to receive any protection. Bank will have to pay the compensation to the customer. A banker is not entitled to debit the customer account on forced check. So in case of forced check, if it's found that signature is forced, then bank does not have any mandate to act on the basis of the instrument. In a joint account, if one of the signature is forced, and then there is no mandate and the bank cannot make payment. if there are two, in case of joint account, the two persons are there, one signature is forged, then also bank does not get any protection. Section 128 says that where the banker on whom a cross check is drawn has paid the same in due course, the banker paying the check, and in case a check has come to the hands of the payee, the drawer thereof shall respectively be entitled to the same rights and possession in all respects as they would respectively be entitled to and place in if the amount to the check has been paid to and received by the true owner thereof. So in the question is, suppose if the cross check means whenever the check is crossed, it indicates that the account the check should be cleared only through the account pay check only. Means it's an account payments or through account only the amount should be paid. So in case of cross check, in due course the bank has done bankers make the payment through the account, then the bank gets protection. In case of cross checks, if you are making payment across the counter, then bank is liable. Otherwise, if the bank is make the payment to the account only, then bank is entitled to get protection. See, the section 131 deals about the protection to collecting banker. Collecting banker means the person who receives the checks on the customers and send it for collection. So section 131 says that a banker who in good faith and without negligence received payment for a customer of a check crossed generally or specially to himself shall not, in case the title to the check proves defective, incur any liability to the true owner of the check by reason only of having received such payment. So suppose if the bank received the checks sent for collection, subsequently it found that the check signature is not, this check is not, is a tampered one, signature is forged. In that event, bank will be protected if the bank acted in good faith and without negligence. These are the two important points you have to remember. That is, bank should act in good faith and without negligence. So if the bank received the payment in good faith and without negligence, bank get protection. But if it found that the bank didn't act in good faith and without negligence, then bank will be under responsibility. Bank have to make the compensation to the account holder. It shall be the duty of the banker who receives the payment based on an electronic image of a truncated check held with him to verify the prima facie genuineness of the check to be truncated and any fraud, forgery, or tampering apparent on the face of the instrument that can be verified with the due diligence and ordinary care. So whenever the electronic image has been sent for collection, the banker who is sending the electronic image has to verify that this electronic image is proper and correct. If there is a deficiency, the banker will be, the collecting banker will be responsible. So the same provisions is applicable to draft also. So truncation we have mentioned, and now see the when we are filing a case under section 138. So how the which jurisdiction used to file 138 case? Because previously there was a lot of confusion when Supreme Court judgment has come. Subsequently, to overcome that judgment, the NI Act was enacted. The NI Act was amended. In Supreme Court of India, in Darshat Roop Singh Rathore v. State of Maharashtra, ruled that a complaint about a bounce may be filed on the check for collection in some other bank. Suppose the check was issued in Kerala, the check was deposited for collection in Bombay, then the place where the check dishonored will be the courts will have jurisdiction where the check has got dishonored. That means if he's got dishonored at the branch in Bombay, then the jurisdiction of the court in Bombay will have the jurisdiction. This creates a lot of confusion because people who was given a check in Kerala, many of the finances and NBFC, many of the finances were financing the motor vehicles, two-wheelers, four-wheelers, etc. They collect the check from Kerala. They may go to the place in Bombay or in Chennai. They will present the checks there. So and they will file a case there. So the person who was given the check in Kerala has to travel all the way to Bombay or Chennai to fight the case. So that created a lot of confusion in the banking sector, and subsequently the NI Act was amended. So the Negotiable Instruments Amendment Act 2015 was passed by Parliament with retrospective effect with effect 15th June 2015. It says that Section 148 says that the offence under Section 138 shall be inquired into and tried only by a court within whose local jurisdiction. There are two scenarios that we mentioned. One is that if the check is delivered for collection through an account, the branch of the bank where the pay or holder in due course, as the case may be maintained, the account is situated. Suppose the check is delivered for collection at the branch of the payee, then that branch will have a jurisdiction. That the courts within that branch will have a jurisdiction. Suppose the payee's account is in Kerala, then the courts in Kerala will have a jurisdiction. That means if a check is delivered for collection through an account, if it's an account by check, the branch of the bank where the pay or holder in due course maintain the account. So the pay is maintaining account in Kerala, then the court in Kerala will have a jurisdiction. So where the pay is maintaining account, where the pay is maintaining the account, that jurisdiction only will have the courts in that jurisdiction will have to try the cases. Second scenario is that if the check is presented for payment by the payee holder in due course, otherwise through an account, if it's not an account pay check, the branch of the drawing bank, that means the bank which issued the check, where the drawer maintains the account is situated. So where the drawer maintains the account, that in case of non-account pay check, in case of bearer checks, where the drawer is maintaining the account, that branch where the jurisdiction lies. So that means the courts where the drawer is maintaining his account will have a jurisdiction to file the case. In case of account pay checks, where the pay is maintaining the account, there I think we'll have a jurisdiction. There the courts will have a jurisdiction to try the offense under Section 138. So Section 138, what are the ingredients of the offense under Section 138? So Section 138 NI Act penalizes dishonor of check. However, dishonor of check is by itself not an offense under Section 138 of NI Act. Just because the check is dishonored, you cannot file a case under Section 138. For a debt, or if the check is drawn only, the provisions of NI Act will be applicable. Suppose for a donation, you are giving some social obligations, you are given a check, then it will come within the definition of 138. So check must have been drawn for discharge of existing debt or liability. Previously, check has to be presented within 6 months. Now in 2011 and 12, RBI has come up with a notification where the period of validity of check has been confined to 3 months. And as of now, the check has to be presented within 3 months from the date on which it was drawn. Third, the check must be returned unpaid due to insufficient funds or it exceeds the amount arranged. So when the check is presented for collection, the check should have been returned with the reason that insufficient funds or it exceeds the amount arranged. So if there is no sufficient balance, the check is got returned. That case only we can file a complaint under Section 138. Fact of dishonor be informed the drawer by notice within 30 days. That means that if the check is dishonored, you have to inform the drawer that your check has been dishonored, and you have to make the payment within 30 days time. So you got the drawer has got a time up to 1 month to make the payment to you. If you failed only, the course of action for the offense will commence. The drawer of the check must fail to make payment within 15 days of receipt of the notice. So after receiving the notice, within 30 days, you have to send the notice to him. And if you receive the notice, within 15 days, he has to make the payment. And if you fail to make the payment within 30 days, within 15 days, thereafter only the cause of action arises. The objective notice required to be given under Section 138 of NA Act is to give a chance to drawer of a check to rectify his omission and also to protect an honest drawer. There is no form of notice as been statutorily prescribed. That being said, the notice must be in writing and it must be issued within 30 days of receipt of information by the bank. So that means once you receive the dishonor memo within 30 days, he has to issue a notice to the drawer. It is worth adding here that while the calculating the period of 30 days, the date of receipt of information for the bank has to be excluded. The date on which you receive the information has to be excluded while counting the 30 days time. Central Bank of India versus Saxon Farms and others. The Central Bank of India versus Saxon Farms. It has been held that the object of the notice is to give a clear chance to the drawer of the check to rectify his omission. If in the notice, the demand for compensation interest cost expense is also made, the drawer will be absolved from liability under Section 138 if he makes the payment of only the amount covered by the check of which he is aware within 15 days from the date of receipt of the notice or before the complaint is filed. So that means the obligation is only to make the payment of the check only. There is no question of any paying any compensation or interest, etc. So the obligation under Section 138 is to make the payment of the check amount only. If the amount, if you pay the check amount, then the rest of things will not be counted, because whether he has asked for the demand for the interest or compensation, that will not be counted under Section 138. Only the check amount need to be paid. Still import versus estimates. Supreme Court had that if the notice envisaged and Section B of Section Section 138 was transmitted by fax, it would be in compliance with the legal requirement. Now even fax or email, you can send the notice that is valid as per the decision of Supreme Court. In Somnath, the state of Punjab, where notice is sent to registered post, presumption of the service can be raised in following cases. If in case unclaimed, even refused, not available, house locked, shop closed, address not in station, all these cases, whatever be the reason, this mentioned reasons, will be counted as a notice has been properly served. Supreme Court in Yogendra Pratap versus Savitri Pandey held that a complaint filed before the expiry of 50 days from the date on which the notice has been served on the drawer accused cannot be said to disclose the cause of action in terms of clause C of the provision to Section 138. Upon such complaint which does not disclose the cause of action, the court is not competent to take the cognizance. That means that the drawer has a time up to 15 days to make the payment in case of dishonor. In before 15 days, if you file the notice of the complaint, it is not maintainable under Section 138. A conjoint reading of Section 138, which defines as to when and under what circumstance offence can be said to have been committed, is which is Section 142B of the NA Act, that reiterate the position of the point of time when the cause of action has arisen, leaves no manner of doubt that no offence can be said to have been committed and unless and until the period of 15 days as prescribed under clause C of the provision to Section 138 has in fact elapsed. Therefore, a court is barred in law from taking cognizance of such complaint. That means that if you file a case for 15 days from the date of receipt of the notice, then the court will not take cognizance of this offence. 15 days time has to be given to the drawer for making payment once he receives the notice. Varsha, I think we'll finish today. I think one more session, I finish it.
Okay. Okay, sir. Is the forum is open for Q&A if any participants have any doubt?
Sir, I have a doubt.
Yeah.
Once the check has been bounced on the basis of the account has been blocked by the banker, then in this case we can serve a notice and file a complaint under section 138 against the person.
Is attached by the police or by the court, that case also complaint can be filed, because The attachment would have been happened because of some activities on the part of the complainant. So the pay is not responsible for that. So definitely you can file a complaint even if there is an attachment by the competent court or by the statutory organization. Attachment will, I mean, section 138 will be maintainable.